May it please the court, Joseph McMurray with the Sullivan County Bar representing the appellant Nicholas Collins. Your Honors, I would like to reserve 5 minutes if I may. Your Honors, this case is about statutory sufficiency. I want to speak regarding three elements here. First is mens rea, second is imminence, and third is the order of protection leading to the aggravated assault. Now, as far as mens rea for aggravated assault or assault, they're tied together in this case. It's the intent or knowledge must be proven beyond a reasonable doubt. And so he either intentionally or knowingly committed this offense. And what did he intend or knowingly do was to create fear of imminent bodily contact, imminent bodily harm. The facts in this case just do not rise to that level. Mr. Collins was a THP officer for several years, going through a divorce. There was an order of protection that was filed against him. And what happened? He actually committed trespass. He came upon the land, he cut a valve stem, and he cut a cord to a security camera. So as far as his mens rea, did he intend or knowingly create that impression, that imminent fear of bodily harm? Once he was discovered, what did he do? He ran away. He ran away. There was no threats, no punches, no contact, no communication, no weapon that was brandished, nothing. He ran away. Now, would that create fear? Yes, it possibly could create fear. But did it create the fear of imminent bodily contact? That's the issue in this case.
Well, didn't the victim testify that she was afraid?
She did. She was afraid.
And the jury heard that and
jury
weighed all of the evidence?
Yes, Your Honor, but as far as her fear, was it fear of imminent bodily contact? She had a right to be afraid. She had a right to not want him on the land. She had a right not to have her valve stems cut. But it was not an aggravated assault. It was an immoral act, one that should not have been done, but it didn't create the fear of an imminent bodily contact at any time. So what is imminence? Imminence is near at hand, impending close.
Did the victim testify that she was shaking at some point in time and had a sense of doom about her when this all occurred?
She did, Your Honor. She did relay that she was shaking and she had a sense of doom. I believe that was the other victim, her stepfather, that actually coined the phrase doom.
And I mean, it's not, I mean, she knew of his history. I mean, clearly she had to get an order of protection against him. He's there in the middle of the night. He's cut the security cameras. I mean, that seems like a pretty intense situation in which someone might be scared of imminent bodily injury, especially knowing he's armed. I know she didn't see him brandish a weapon, but he admitted to being armed. Isn't that just for the jury to determine?
Judge, it is, but it's also, there needs to be parameters set in place of what is imminence. What is imminence? And you're right, the Tennessee's courts, we take a very loose interpretation of temporal, what is imminent and what could be. He doesn't actually, the defendant doesn't actually have to create a situation of contact or imminent bodily harm. It's whether or not that person's fear is reasonable. That is the ultimate question.
Well, isn't her history with him and her testimony about his erratic behavior and the fact that he is armed as a trooper, I mean, that to me goes to as evidence about whether she was reasonable, reasonably feared for her, that she might, have bodily injury from him. And again, that's all evidence the jury weighed. So I'm struggling a little bit with how we get to where you want us to go.
Well, I think I could pinpoint us in the right direction, and it's a concurrence of the elements. It's basically, at the time she was afraid, okay, was it a fear of imminent bodily injury? And I don't think at any point does any of the evidence rise to that level
So
of a
there,
fear.
she's there, she knows he's on the property, and he's cutting the lines to the security feed. She knows all of that.
She doesn't realize that till she comes to the front door, and once she's at the front door, he's already down past the driveway running away.
So you're saying just because he ran away, that solves
Well,
the
I
issue
think-
for you?
I think that, and I'm sorry to cut you off, it was at the end of your question. I think the fact that he ran away goes to his mens rea, his intent. Was his intent there to actually cause that fear, or was he trying to be the white knight? Would she call him the next day, hey, I need your help, my tires are flat? What was his intent at the time of
But he could have known he was causing fear. He either had to intentionally or knowingly cause her to reasonably fear imminent bodily injury. I don't know how he could not have known, based on their history and the fact that he's there in, dark hours of the morning, cutting the lines to the security to the home where she's living away from him because she's afraid of him.
And with all due respect, I think at the time that she has every right to be afraid. And it is a reprehensible act. He should not have done it. But does it rise to the level of an assault at that time? Is she committing an assault? Is he committing an assault on her and the
What
other
else is he
occupants?
doing?
Yeah, if he knowingly caused her to reasonably fear bodily injury, those are the elements of assault.
Right, imminent bodily injury. And my argument is there was no concurrence. As far as the imminence, there was never any point at hand where a reasonable trier of fact could actually find that she had a reasonable fear of imminent bodily contact or bodily injury at that time.
Counsel, you're asking about imminence, so I had a question about the timing, okay, of the fear. Is it clear in the record when she said she became afraid, when she realized whatever she testified to?
And Your Honor, that's a really good question. I think when she testified that when she woke up, she knew something was wrong because she heard the security alarm go off. And once she saw the individual running down the road, the driveway, the road, that's when she became afraid, she was shaking, and she called 911. And, Your Honors, I think that actions in and of themselves of the defendant can be reprehensible. It's unlawful, trespass, vandalism. Totally understand that. But as far as the parameters of when and where we define an assault, I do think that there needs to be guardrails. Anytime that someone commits a violation of order of protection, ultimately, that will create a fear. That will create a fear in the victim. Is that an assault? I think what I'm asking for is the guardrails for an assault of imminent bodily injury. And I don't think that the facts support it in this case. And I don't think that the state actually has the evidence to support that. And I would yield 5 minutes.
Thank you, Counselor.
Good afternoon again, and may it please the court, Caroline Weldon on behalf of the state. This court should affirm the defendant's convictions because the evidence is sufficient to support his convictions for assault, domestic assault, and aggravated domestic assault. Though he was convicted of a number of offenses, he takes issue, as he said, with only 3: the assault of his stepfather-in-law, Mr. Gibson, and the domestic assault and aggravated domestic assault of his then estranged wife, Mrs. Collins. Context is important here, and given the nature of his arguments, I think it would be helpful to very briefly review the events that occurred just before the night in question. The defendant and Mrs. Collins were married for 11 years before she told him that she wanted a divorce in January of 2022. 4 days later, she took their 2 minor children and moved in with her mother and her stepfather, Mr. Gibson, to their house in Kingsport, Tennessee. And over the next few weeks, the defendant's behavior became erratic. He was then a Tennessee state trooper who carried a gun all the time. He sent her messages that said that he knew where she was every day. And just after Valentine's Day, he sent her a video in which he appeared to empty the remains of her father into the trash, accompanied with a message that said he had just taken her dad away from her. So the next day, she sought and received an order of protection against him, which specifically directed him not to put her or their minor children into fear of being hurt. And he was served with that order of protection the next day. 2 days later, at 3 o'clock in the morning, all of the motion sensors at the victim's parents' house alerted simultaneously. And when Mr. Gibson attempted to access the surveillance camera through his cell phone and then his iPad, he discovered that the system was in communication failure. The victim testified that she began shaking and that she felt a sense of doom. When her stepfather went outside, he heard the loud hiss of air spewing from a tire. He heard the sound of someone running and saw the defendant's truck down the street with its taillights illuminated, and it's undisputed that the defendant was running away from the house at that point. The victim's stepfather, Mr. Gibson, discovered that the wires to his security system had been cut in 2 places and that the valve stems of tires on 2 different vehicles parked out front of the house had been cut. The victim's license plate was also missing, and the defendant was arrested soon after. When he was arrested, officers searched his truck and recovered a handgun, a holster, magazines, and ammunition.
But if they saw him running away, is it reasonable for them to have fear of imminent bodily injury?
Yes, I think that the fear of imminent bodily injury occurred when they heard the motion sensors being tripped that surrounded the house, and they reasonably assumed that it was the defendant who had just received an order of protection not to have any contact with her or their children who were inside the home.
Was that question asked? Same question I asked him, when she became afraid?
Yes, she became afraid when she heard the sound of the motion sensors tripping.
I know he was acquitted of it, but what was the state's theory on the attempted murder?
I don't think that's developed in the...
Was he not indicted on that, or am
No,
I getting
I'm
mixed
sorry,
up?
Your Honor, I answered too quickly because I believe other charges were dismissed. The state's theory of attempted murder, I would have to guess went to the fact that he did bring a weapon with him in his car when he came to their house.
Also, that's the basis, or part of the basis for the aggravated assault, right? The gun?
Yes.
Okay. Not the valve stems?
No, not the valve stems.
Okay.
I don't believe so. No, Your Honor. Beginning with the defendant's argument as it relates to his stepfather-in-law, the evidence is sufficient to sustain that conviction because a jury could have concluded that the defendant acted intentionally or knowingly. As I said, 2 days after he was served with an order of protection, he drives up to this house in the middle of the night where he knows his estranged wife and children are asleep. He parks his truck down the road, creeps up the driveway, tripping the motion sensors, and waking the family. Mr. Gibson was aware of his stepdaughter's issues with the defendant, and he was unable to access his security system because the defendant had tampered with it. So he arms himself and in his bathrobe begins canvassing the yard to see where the defendant might be. And when Mr. Gibson recalled those events for the jury, he said that they left him feeling unnerved. The defendant, as a former member of law enforcement, certainly would have known that such a late-night visit to a forbidden address would have caused Mr. Gibson to fear imminent harm. And such evidence was sufficient to show that the defendant acted intentionally or knowingly.
I had a question in your brief. The statement was an admission that the defendant's admission that he armed himself, and then, is that correct when the defendant was interviewed and the detective asked, "Did you have a pistol?" And he said, "I did, sir." "Do you always carry a pistol?" And he said, "Yes, sir." Is that the extent of defendant's admission? He had the pistol on his body as opposed to in the truck?
I don't believe, I believe he just said he had it with him, and I don't know if he ever said that it was holstered or on his person.
But when he was arrested, it was found in the truck, wasn't it?
Yes, it was.
Okay.
Yes, but I don't believe that he ever admitted or that there was any evidence of him physically having it on his body.
He was never specifically asked, when you ran up to the house, cut the wires and the tires, did you have your pistol on you?
I don't believe so.
All right.
But he was arrested very shortly after he left the house, and the weapon and the ammunition were recovered from his truck. And the victim testified that he was always armed. That was something that was his custom, and he even, there was testimony that he even was armed when they went on a family vacation to Dolly World. He just always carried a firearm.
It's a rough place, Dollywood.
Well, I guess it could be. The defendant makes the same arguments as it relates to his then wife, claiming again that the state failed to establish that he intentionally or knowingly caused her to fear imminent bodily injury. Again, there is overwhelming evidence to the contrary. She had just tried to end their 11-year marriage and had him served with an order of protection. He comes to this address in the middle of the night and tampers with the security system that they had in place to feel safe during a difficult time in their family. So from this, a jury could find that the defendant is guilty of domestic assault. And then with respect to the aggravated domestic assault, a person commits aggravated assault who, after having been enjoined or restrained by an order, commits or attempts to commit an assault against the individual. And the proof shows that the defendant did assault Mrs. Collins after he'd been personally served with an order of protection against him.
And that's the theory under which they proceeded and also was what was charged to the jury.
Yes,
correct?
Your Honor.
Yeah.
And so for all those reasons, we'd ask this court to affirm.
Thank you.
Just very briefly, yes, he was, there was an indictment for attempted murder as well, and the state's theory was the same. As far as the issue for the gun, I don't think there was any testimony that was ever developed as far as him having the firearm on him while he's on their property. The firearm, as you stated, was recovered inside of his truck in his vehicle miles away from the house, approximately 45 minutes later.
Did the questions that I recited, did you have a pistol? I did, sir. Do you always carry a pistol? Yes, sir. Was that the prosecutor and the defendant, or was that a police officer and the defendant?
And Judge, you've got a better recollection than I do.
Well, I wrote it down.
Oh, okay. Your Honor, and I don't want to misstate. I really don't. But I do believe that, because I tried the case, and I do believe that I asked him that question directly, and obviously the record would be a much better reference than my memory. But I knew Mr. Collins very well as a prosecutor, and so I handled his case for him. The only issue, I guess, that I really would like to try to make is that there's got to be a difference, that we do need to draw a line. And what I'm asking this court to do is, not every time you violate an order of protection, it's not an assault. So there is a difference somewhere. But I would argue and submit to the court that any time an order of protection is violated, it does create fear. But that fear is not of imminent bodily injury. And so I believe we have that case here before us today. And what I think we can do, we can draw the line and create some consistency, which would be in the interest of justice. And I understand that, yeah, it is a jury question whether or not it's reasonable. But we live in an age today that, some people take some words as violence. and as offensive, as a threat to their person. If the courts can create some consistency from Memphis to Mountain City of what actually is imminent bodily injury, or at least provide us some with guardrail. And I think this is the perfect case to do that. There was absolutely no evidence that there was any kind of assault that was going to take place on the property that day. Yes, there was fear, but my argument is that fear was not tied to any imminent bodily injury. Thank you.
Thank you, Counselor. Thank you both.
Good.
Call the next case, please.
State of Tennessee.